discussion. One other point. The allegation has been made, and I don't know the truth of this, that WikiLeaks is an organization that has not only released the information on the internet, but that has been engaged in the solicitation, the facilitation, maybe even the payment of, I don't know, if pay for information or pay to facilitate the acquisition of the information. But do any of you have any thoughts on whether there is a need to change the law in this area, or is there adequate law right now against what most people would agree would cross the line between reporting and espionage?
Well, first of all, there's a lot more we need to know, Congressman.
I agree with that.
Yeah, that we don't know. But for example, obviously, Amazon, Visa, MasterCard, with their denial of service in recent weeks of WikiLeaks, was pressured by the U.S. government. The U.S. government did not say, cut off the New York Times or the Washington Post. And that is a tip of an iceberg.
I appreciate that that's an issue, Mr. Nader, but it doesn't address the answer to my question, which I've already exceeded the time. Does anybody have any comments on the issue of whether or not we need to strengthen our laws regarding the kind of things that were done or alleged to have been done by WikiLeaks to acquire this information or any other information from the government? And I would contrast from what they acquire from a corporation. But
if I may,
yes, sir, Mr. Wayne.
Mr. Goodline, Congressman Goodline, I don't know whether the WikiLeaks did go about trying to procure or pay for the information, but if there was any complicity between WikiLeaks and the person who actually pulled the information out of the government, then WikiLeaks could be charged as an aider and abetter or a conspirator of the leaker. That person, then WikiLeaks would not enjoy whatever additional First Amendment protections they have as a news organization. Rather, they're charged because they, as a conspirator or aider or abetter of the person who is a leaker. That would be an easier case to make, because then they'd be charged like the leaker and like the 4 other leak defendants that have been charged by the Obama administration under the Espionage Act, in a way that I think is much less problematic to people, because it's not going to, they're not going to be charged as a press organization, rather as someone who's complicit with the leak.
That's under current law, correct? Mr. Vladeck.
I agree with that. All I would add is it may not be as problematic, it would certainly be as unprecedented. The Espionage Act has not previously been used, to my knowledge, to prosecute someone on an inchoate theory of liability as an aider or abetter, a co-conspirator, etc. The text of the statute may support it. I do think we would still wade into some of the issues you've heard us describe this morning about applying this antiquated statute to this novel theory.
Thank you, Mr. Chairman.
Thank you very much, Bob Goodley. We now turn to the gentleman from Virginia, Chairman of Subcommittee on Crime, Bobby Scott.
Thank you, Mr. Chairman, and thank you for calling this hearing. You know, one of the problems in passing criminal laws is there are a lot of challenges. If we pass a criminal law, we expect it to be challenged on its constitutionality, so it has to be consistent with precedent, and we have the Pentagon Papers, which alerts us to the fact that anything we do in this area is going to be problematic. It's also the law has to be precise. It can't be subjective after the fact. Well, in this case, I think it's bad enough to prosecute. The conduct to be prescribed has to be precise. I'm inclined to think that what happened in the WikiLeaks situation ought to be illegal. But I think we have a consensus on the panel, if for nothing else, that we ought to take our time and get this thing done right. Let me just ask, I'm going to throw out a couple of issues and just ask everybody to kind of respond to them, one of which my colleague from Virginia just talked about, and that is, should it matter whether you helped to obtain the information or you got it, slipped under the door, you didn't have anything to do with it in terms of your publication? And does it matter if you knew full well that it was classified? And should it make a difference that it should or should not have been classified? And second, we've heard a lot about the intent to harm or whether it actually harms. And that's going to have a real problem with practicality in criminal law, because whether or not the leak actually harmed, I mean, if you did something to sabotage the Iraqi war and we started that debate, there'd be a lot of people that would conclude that you did more good than harm, although obviously if you lose that debate, you've committed a crime. And whether or not, even though it did harm, you didn't intend for it to harm. Should that be a defense? And the fact that you redacted some of it but didn't redact all of it, should that help you or not? And part of this is, from a practicality point of view, you're up here, you've been arrested for publishing the material, and do you get an opportunity to debate the Iraqi war before a jury? And if you win the debate, you're not guilty. If you lose the debate, you're guilty. If you are lucky enough to be in one jurisdiction where they hate the Iraqi war, you're in good shape leaking the material. If you get stuck in another jurisdiction, you're in deep trouble. Same crime, different jurisdictions. From just a practicality point of view, can you talk about some of these kind of issues? And I just yield the panel the balance of my time.
Congressman, let me give you quick answers to four and hopefully start the discussion back from the experience about these cases. Theoretically, whether or not a media organization or a third party protected either by free speech or free press or petitioning the government changes the dynamic when that organization is, as you or others have said, or Mr. Goodlatte has said, complicit in the theft or the leak on the front end. The problem, again, is the slope. Press people cajole, encourage, flatter, talk to people in the government all the time. They are actively engaged in trying to find out that which the government does not want to disclose. They are involved. They're not taking out a National Enquirer check of $1,000 and paying for the information. We think that's a clearer line, although under the First Amendment I'm not sure it is. But where do you draw the line then when a journalist is doing her or his job very well and is figuring out ways to cajole somebody to say that which they are trying not to? So theoretically, I think yes, but I think practically no. I think the issue of whether the media or the third party or the protected entity knows something's classified, well, the present law doesn't make the disclosure of classified information the crime. It makes disclosure of what's called information relating to the national defense a crime. And we are now seeing with classified overclassification that the fact that it's classified may give a presumption that there's a potential danger in its release, but it's the beginning of the conversation not. And I don't think that's going to be a meaningful distinction today. When you redraw this law someday, it may be one, as again Congressman Goodlatte was saying, how can you prevent overclassification by making sure there's a defense, for example, that if something is improperly classified. So therefore, knowledge that it's classified is not really going to be dispositive. The intent is very difficult, so you're right. There shouldn't ever be a law that says whether or not the outcome was what you intended. That is, I intended to submarine the policy of Iraq, consequently I did what I did and it didn't submarine the policy, or in retrospect it was better to do than not do. It has to be at the front end. It has to be intent. Was your intent to? Now, that is, as you know, the same in every criminal case. Trying to divine a defendant's intent by whatever their direct statements or circumstantial evidence are is going to be the challenge, even in a classification kind of a case. So again, somebody saying to the government, gee, should I redact? Somebody who meets in public, somebody who does things overtly, as opposed to somebody who wears a disguise and is dealing in drop boxes in the middle of the park. You can tell the difference between what somebody's intent is by their behavior. And finally, you raised a really excellent last point. They were all excellent, but this one, as a trial lawyer, when you are divining somebody's intent and you're saying, I felt like I needed to expose the fact that there were no weapons of mass destruction, that plays differently to a jury in Alexandria, Virginia, than it might in the Washington, D.C., than it might in some other place in the country. And that's why, among other reasons, at least the presumption is so many of these cases are brought in the Eastern District of Virginia, or at least the prosecutors believe they have a more sympathetic jury.
Can I just add briefly, Congressman, you also raised the specter of putting the jury in the position of deciding whether something was rightly classified or not. And I think it's important to keep in mind that if Congress were to add an improper classification defense into any revision of the law, you're still putting an incredibly high burden on the putative defendant, who's taken quite a substantial risk if he really thinks that at the end of the day, his freedom, whether he's going to go to jail for 25, 30 years, depends on his ability to convince a jury that something was wrongly classified. So I think that's not a legal argument, but I do think that that puts a pretty heavy thumb on the scale of why that would not open the door to massive leaks by individuals who thought that things were wrongly classified. Those are pretty severe consequences to take such a long shot on.
Mr. Chairman, Mr. Congressman, I would just add to what my colleagues have said, but a number of them have suggested we should alter the law to have an intent to injure, and this was one of your points. I think there's reason to believe that would open the floodgates for leakers, that there are many salutary reasons for leaking, but there could be considerable disagreement about what actually is salutary. And the current law, which demands that you have reason to believe it could injure the United States, seems to capture behavior that we would really like to keep from occurring, keep genuine secrets secret.
Well, what burden of proof would you have if somebody honestly believed that this was good for the country, although some juries would conclude it's bad for the country, others would? I mean, do you have to prove, would the prosecution have to prove beyond a reasonable doubt that he did not believe that what he was doing was the right thing?
I'm not sure of the answer to that.
I think it's important here, again, to distinguish between...
So are we talking about a good faith exception to leaking?
I think it's important to distinguish between the leaker and the publisher. The leaker can be regulated consistent with the First Amendment much more aggressively. And there I think it's sufficient to say that knowing disclosure of classified information that's properly classified, punishable.
Congressman, one more thing on your last point. You know, the present statute and the glean by courts as to the intent requirement to show, as Mr. Schoenfeld pointed out, that you had a belief that it could injure, whether that's good enough. Let me tell you why it's not good enough. What does could injure mean? What if you believed there was a 1% chance that it could injure and a 99% chance that it wouldn't? Where in that slope does somebody become a felon subject to 20 years in jail? And that is difficult, especially difficult in a First Amendment context.
I mean, I think, Congressman, I think the short answer is you don't write one statute, you write three. Right, and that you have one statute that is focused at espionage and spying. You have one statute that is focused on leaking, because as my colleague Professor Stone points out, you can impose higher burdens, you can hold government employees to a higher standard, and you have a third statute that deals with private citizens with no intent to harm the national security of the United States. Now, that statute, I think, is the incredibly tricky one to write. But no matter how it's written, I think having those categories separated out would be such a substantial improvement, and recognizing that the burden should be different in those three cases would be such a positive development as compared to the status quo that really, I think, almost anything would be beneficial.
There's great benefit in having a very rigorous and narrow statute to punish the publication of the information, because that puts pressure on the government to keep the secret in the first place. So they can't punish WikiLeaks because they don't have the requisite intent or they haven't caused the requisite harm. And they know that, and they're serious about the secrecy. They will then take the steps necessary to keep the information secret. And in that dynamic, I think it's very important not to make it too easy for the government to try to prosecute the ultimate speaker, because if they can do that, then they'll get lazy and sloppy on the question of secrecy itself.
Thank you very much, Bobby Scott, for that interesting exchange. I turn now to the distinguished gentleman from Iowa, Steve King.